Hello and welcome to the Husch Blackwell Labor Law Insider Podcast. I'm Tom Godar, your host, and I'm glad that you've come along. In this podcast, we welcome guests with practical expertise and experience regarding labor law issues, and they share their insights related to this ever-changing area. The breadth of developments in laws related to unions and individual workers' rights that we are experiencing under the Biden-appointed National Labor Relations Board and led by General Counsel Jennifer Abruzzo is unprecedented. These developments demand that employers and those giving counsel to organizations stay tuned into these changes and make necessary adjustments to their practices and to policies. When President Biden was elected, he promised to have the most union-friendly administration ever, and he is fulfilling that pledge. So buckle up and hang on for this wild and wonderful ride in the world of labor law. Welcome back to the Labor Law Insider. We're really excited to have you join us for part 2 of our discussion of the labor law developments in 2023 and what we can anticipate in 2024. Rufino Gaitan and Adam Dorr have been helping me with this Labor Law Insider podcast, and we're going to continue our discussion of some of the major developments that occurred last year with the National Labor Relations Board, and then some of the ways in which you, our friends and clients and guests, might anticipating taking steps to, ameliorate some of the potential problems that would come if you are not ready for the changes affected by labor law in 2024. Let's start again with you, Adam.
Thanks, Tom. It's great to be back recapping the labor law whirlwind we saw in 2023. We talked quite a bit on our last episode about CMEX, which turned union organizing and voluntary recognition on its head, and the board's Stericycle decision, which made at least 5 work rules in every employer's handbook unlawful under the Act. We also talked about strike activity and a number of other issues. But we didn't get to talk much about the NLRB's direct attack on confidentiality and non-disparagement rules in severance agreements specifically, but really in any other context.
The upshot for me as I read those decisions, the McLaren decision and the GC memo, is that we can't restrict employees' rights to talk about the circumstances leading up to the severance, because that is relating to the terms and conditions of their employment at the time, or the existence of the severance, because that too is part of the conditions of their employment, albeit the separation of their employment. What we have to now limit that to then is confidentiality of the financial terms, which the general counsel suggested is still fair game to maintain the confidentiality of, and then limit the kinds of comments that are maliciously false or knowingly false instead of just the facts and circumstances leading up to the severance.
Yeah, and you think about that as well, big deal. And so you don't have a non-disparagement clause in there or a confidentiality clause and so forth. But the reality is that some of these toxic employees who have to be let go want to have a big mouth, and they want to brag about how they got the employer and how awful the employer was. So some of my clients are just not going to be at all excited about having an agreement that doesn't have confidentiality or non-disparagement. Rufino, are there other ways to skin that cat, or are we sort of stuck?
I think it's a similar calculation here in terms of the risk, right? You can try to include those non-disparagement type restrictions in the agreement and, the confidentiality as well, and hope that the employee actually just lives up to the agreement, knowing that you have a risk with the board. At the end of the day, though, whenever I bring this issue up to clients at the time of offering somebody a severance agreement, a lot of clients have opted, and I've seen that this is, of course, just anecdotal from my practice, but I've seen more clients decide not to offer any severance at all and take their chances if the employee files any sort of a charge, because they don't want to have to deal with this uncertainty of, if I pay this person a pretty tidy sum of money to keep quiet, but I can't actually enforce them or enforce that requirement, like, what am I really buying? I'm buying just the security of not being sued, but even then, that's a somewhat of a limited restriction as well. So I think that if the board was trying to create a more favorable field for departing employees, I don't know that that's working, because I think the flip side is some employers will just say, okay, we're not going to give you anything because we can't actually buy your silence. And if you're going to go be loud about it anyway, we will preserve our opportunity to defend our claim anyway.
You can go pretty far on including things like non-defamatory conduct, but beyond that, it's going to be very difficult to have something that might not be non-enforceable and even itself be a ULP, oddly enough, under the Stericycle decision. It's a world of difference, and I would call 2023 maybe the change in risk calculus. How are you looking at the risks that have been created by a number of things, including board action, both GC General Counsel memoranda, as well as the cases that have been decided, which are going to be subject to appeal. We'll see if the courts love all of this stuff. But the other part of the calculus that I want to sort of switch to right now is what I'll call the warm and fuzzies about unions and how that has affected their ability to use strikes as a mechanism to make greater demands in the marketplace and to engage in union organizing. And they can do both of those things with more tools now than they had previously. So we've heard back in various times of the year, I think beginning in June, July, August, the 2023 was the year of the strike. And now we've got the whole thing in the bag. Adam, was 2023 a time when unions felt striking was going to once again be advantageous to them? It had almost all been but abandoned for a decade or 15 years.
Strikes have certainly been, strikes and other labor activity. It's hard to always pinpoint and label a protest and picketing and strikes, put them in their respective buckets. But overall, labor protest and strike activity did continue to rise in 2023. And that was after a surge in 2022, which came on the heels of Striketober in late 2021. So the unions have continued to push forward with strikes and similar activity. And that increase sure did carry through to 2023, including with some very high profile strikes in a time when interest rates and inflation were through the roof. And just it was quite an impressive run of strike activity and at least claims of success too. It's hard to always know exactly what the delta is that comes out of a strike, but certainly a lot of headlines and a lot of seemingly favorable press for the unions.
Yeah, GM and Ford and the Chrysler organization all had the big three response to the strike activity. And it didn't take money out of all of the employees' pockets, which is one of the big deals for employers, right? To say, if you want to go on strike, you're going to have one hell of a big increase, which I'm not prepared to offer to ever make that up in a lifetime. But when you only have 10% of the employees engaged in the bargaining out at any given time, it doesn't necessarily nick everybody's pocketbook. It becomes an even more potent weapon. Interestingly, in Wisconsin, one of the units found out that their plant was being closed as a result of the negotiations, even though they too were on strike. Weird stuff like that. So do we predict that we're going to continue to see this move towards job actions, towards work stoppages, towards protests and picketing in 2024? Rufino, what do you think?
I believe so. I think that the unions have come to the conclusion that this is an effective tool for them to use. I don't know how effective it actually is. I mean, you mentioned the cost issue a bit, Tom, but I do think that in many situations it does become a drain on the employee. And certainly employers, suffer financially as well from lost revenue or production as well. Sure. But they're in a much better position typically to hang on and kind of outlast the employees. The thing that I think sort of gets lost in the weeds with strikes sometimes is this idea of, extracting more money from employers. And if you do that, you can do that by hitting the employer by creating a disruption to their production. I think it's not as cut and dry as employees tend to believe. I do believe that, at the end of the day, if you are an hourly employee and you are not coming into work, you're not going to get paid. And you have to do the analysis of, if I miss a week of work for this strike, how much of a raise do I need to get in this contract to actually make up for that lost money? And then at that point, you're just breaking even. So whatever you're going to need even more than that. So the longer the strike lasts, I think it becomes even less obtainable for an employee to reach the goal that they really want in terms of bargaining. I think the better option in terms of strike activities and things of that nature are to engage in those sorts of methods like you mentioned, Tom, where only a percentage of the workforce is coming in and out. And they obviously need to do that in a way that, is still impactful and hurts the employer's bottom line, but not necessarily the entire unit. But from my own, again, just experience in the last year or so, I've definitely seen an uptick in even just the threats of strikes, right? I mean, that alone is something that makes an employer kind of pause a little bit and think hard about where their bargaining position should be. And the fact that more and more unions are actually following through and engaging in strikes activities, I think should be on every employer's radar, especially those who are currently unionized.
I agree, Rufino. I just have two things to add to that why I think that strike activity will continue in 2024. And that's because I think, one, a lot of contracts maybe haven't had the chance to go through collective bargaining since coming out of the pandemic in 2021 or 2022. So they might feel that this is their first chance to threaten or go out on strike if there are CBAs coming up for negotiation this year. And with the presidential election looming this fall, unions might see this as at least their last sure chance to have a friendly administration. We don't know what will happen in November, but at least until then, I think unions are going to continue their push very hard.
So we've had more than 500,000 people affected by work stoppages last year. The other thing that we're seeing an increase in is union organizing activity over the past few years. We've seen a number of different scenarios, and union win rates have increased. Adam, tell us a little bit, first of all, about what the unions are doing in the organizing world in 2023.
Unions are just cool now again, I think. It's when you look at the polls, it's shocking how dramatic the difference is in union sentiment based on age. Of all the different factors, that seems to be the single largest difference. Today's youngest workers are the ones who most, at least publicly, say that they support unions and they have a positive impact. So for one reason or another, unions have done a good job being cool again. And I don't know if that's just part of the administration's work as well. But that, to me, is one thing that tells me that this isn't going away anytime soon, because it's not just about somebody's political ideology or anything else. It's a generational difference.
And so we have somewhere between 1,300 and 1,400, maybe even 1,500 elections last year, depending on whether they were just RC elections or others. And the unions were winning more than 70% of those elections. How does that compare, Rufino, to union election activities over the last decade and the last few years?
It's certainly an increase in the win rate. Typically you have a little bit more of a level playing field in terms of the outcomes. But you also have to keep in mind that when a union either demands recognition or files a petition for an election, they already believe they can get majority status. And they've been planning this for months ahead of time before the employer catches wind of the fact that there's an organizing drive going on. So you expect to have, better than 50% outcome for unions here. That said, to Adam's point, there is, I think some of that success in recent years for unions can be chalked up to this idea that, yeah, they are cool again. They are making very good use of social media in a lot of instances. If we go back to the Amazon situation where Amazon had a former employee arrested on their grounds, and, that is sort of course, recorded on video and then spread on social media. There's this sort of sense of like a social justice component, which also coincided very heavily with all of the political issues that were going on a couple of years ago, and especially with regard to police, issues and all of those things. So the media coverage around it, I think, has certainly helped. If we go to 2023 with the screen actors and the writers, again, that is a demographic that just by its very nature is sort of cool, right? I mean, these are the people who make and produce and write shows that we use for entertainment and can all sort of relate to. And they're using a lot of those different media issues very effectively. And I do think that to the extent that an employer has any sort of indication that an organizing drive is going on in their workplace, their most important issue is going to be to try to communicate with those employees and to try to address as many issues as they can before an election petition is filed.
You talk about the social media and all that. I think part of it is also how unions have done a good job of getting out the message that union busting is disgusting. And so any resistance or opposition or refusal to just let a union in by voluntary recognition, that automatically gets companies labeled a union buster, and the bad press that comes along with that. I think that's also helped fuel the generational change and the social media use in organizing.
I agree 100%, Adam. There have been many clients over the last couple years who are very hesitant to even mount any sort of a campaign against the union effort, right? So they take a very hands-off approach, and as expected, it results in their workforce becoming unionized. I do think that employers need to keep in mind that the short-term benefits of not being labeled a bad guy or a union buster or a non-union friendly, establishment, those gains impact your workplace potentially, forever, because now you've got this bargaining representative that is charged with negotiating on behalf of your employees. So you have to take that into account when making those decisions about how to campaign, if at all. But, you shouldn't just do it to avoid the negative press that you might get in the short term.
We've talked a lot in the last year or two on the Labor Law Insider about these changes. And when I ask, as I normally do towards the end of a podcast, so now what? Lots of times the answer is greater training, awareness, and so forth. I would think that we have to triple down on that. That is that you have to go and take a look at your handbooks and determine whether or not they may have some provisions that under the Stericycle decision are not going to pass muster anymore. That you're going to have to look at training your supervisors and your line staff about positive employee relations without giving up, your ability and your need to appropriately and proactively manage. And your last comment about, unions are cool and busting is disgusting, suggests that you better have your campaign before the union shows up. In other words, you better be investing now, or at least my advice to clients is investing now in positive, proactive relationships with your employees so that you don't have to look like the bad guy becoming educated when the union shows up, but say, no, look, all along, we've been protecting our joint interests. We are together in this. Are we seeing a move towards those kinds of activities by our clients, or are we still seeing a little hesitancy because they might not have been touched directly by a union campaign or a threat of a strike?
There's still a fair amount of hesitance to, I think, recognize or admit that a company is vulnerable to union organizing, or maybe there's a lack of time, or it's not in the budget. There's 100 reasons why we might wait till tomorrow, quote unquote, to address it because it doesn't feel urgent today. But I am seeing more clients ask for a review of their existing materials or a pulse check on what they should be keeping their eyes out for, or doing that frontline supervisor training just so that they know what to look out for and what it means. And that's critically important. At a minimum, making sure you know who your supervisors are and make sure they know what to do, even if it's just to run it up the chain so we can get going. But the more that you can have this prepared and ready to go beforehand, the less you'll be chasing that 20-day window that we now have before an election.
Good advice, Adam. And Rufino, last word, thoughts as we close out 2023 and look to 2024.
Absolutely. I like to tell clients who do not yet have unions, ask yourself, what do I need to do as a manager or supervisor or executive to really make my employees think hard about whether to support a union? So in other words, if the employee asks, themselves, what can a union do for me here? If the list is, 2 pages long, good luck. If the list is only a couple of items, you're in a really good spot. So that it really demands communication between management and the employees to understand what issues make the employees tick. How do you address those problems when they become recurring problems, especially? You want to make sure that you have a plan of action to address them, resolve them, and prevent them coming up again. So being proactive really, and it doesn't mean you have to spend hundreds of thousands or even tens of thousands or thousands of dollars. You just need to focus on how do you make life at work better for your employees, and how do you explain to them when you can't do some of the things that they really want you to do for them, whether it's a cost issue or those sorts of things. Transparency is the word that I have heard more in the last year when it comes to collective bargaining than I'd ever heard in my, prior 13 years of practice as a labor attorney. So employees want to understand the decisions you're making and why you're making them. And the more you communicate with them about those issues, I think you have a much better relationship with them. And it makes that question of whether I need a union a little bit more favorable for you as the employer.
I love that. I summarize that sort of attitude as treating your employees like adults, giving them information that's the same kind of information you use to make decisions, especially hard decisions. Trusting them to understand that hard decisions sometimes have to be made. But this has been really helpful. I know that, were I on the other side, that is not the lawyer, but the client, calling you up and having you with a sort of outside view that's broader than just that one organization or even one industry or one geography is going to be helpful. And I hope that our listeners have felt that as well, that this broad stroke treatment of what happened in 2023 and what it augurs for 2024 allows you to be a little bit better prepared for what is likely to be a pretty challenging next couple of years. So, gentlemen, thank you very, very much for joining the Labor Law Insider podcast, sharing your experience and your insights. Thanks so much.
Thank you.
Thanks for having me.
Take care now.